Please, are we all ready? Okay. Good afternoon, distinguished friends from the media. As always, we are grateful to you for the opportunity to address the nation and by extension the world on the court's proceedings on the 2020 election petition, a matter which is of considerable public interest. Several things happened in court today. The first was that counsel for the petitioner moved an application for leave or an application for review of the court's decision on 16th February, which is the court's decision on our application for leave to reopen our case so that we could subpoena the chairperson of the Electoral Commission to testify. Now, for those who are not lawyers, an application for review is a right given to any party dissatisfied with a decision of the Supreme Court to apply to the court and invite the court to respectfully review or change its own decision. And Article 1331 of the 1992 Constitution and the decisions of the Supreme Court has made it clear that you can apply for review of the court's decision, and in fact the court will review that decision where there are exceptional circumstances such as fundamental errors of law committed by the court which have occasioned a miscarriage of justice. And so today's application for leave that counsel for the petitioner moved was to achieve just that, to demonstrate to the court that in its decision of 16th February, certain fundamental errors of law were made, and to invite the court to remedy or rectify those errors by reviewing its decision in the interest of justice. Now, the grounds that counsel for the petitioner relied on in moving this application was that, one, you would recall that when counsel was moving the application for leave for the court to allow us reopen our case, he was asked in what capacity he was seeking to call the chairperson of the first respondent, and he answered by saying that the petitioner was going to call the chairperson of the first respondent, the EC, as an adverse witness. And so you would recall that in the court's decision, the court stated that in their opinion, it was wrong for counsel to have said that he will be calling the chairperson of the first respondent as an adverse witness because per the Black Law Dictionary, a witness can only be described as an adverse witness after the witness has entered the box. And if it is detected during the evidence in chief of that witness that he or she is giving evidence adverse or contrary to the case of the party examining him or her, then that witness becomes an adverse witness, and counsel can then apply to the court to treat the testimony of that witness as that of an adverse witness. That was the decision of the court. Now, ground one of today's application argued that that decision of the court was a clear fundamental error because it did not take into cognizance Section 72 of the Evidence Act. Section 72 of the Evidence Act is simple. It says that subject to the discretion of the courts in a civil action, a party or a person whose relationship to that party makes his interest substantially the same as a party may be called by any adverse party and examined as if on cross-examination. And so if you are a party or you are a witness or any person and your interest in the case is substantially the same as a party in that case, then an adverse party can call you to give evidence. And so in our respectful submission that we made to the court through counsel for the petitioner one does not have to enter the box before that person can be described as an adverse witness, and that Section 72 of the Evidence Act allows a party to call a person whose interest in the case is substantially the same as another party in that case as an adverse witness. And so for us, the court's decision for this reason was per incuriam. Per incuriam basically meaning that it was without recourse, or it did not apply this section. And for us, this is a very serious fundamental error, because as the court itself has held in several decisions, the court is the servant of the legislature and must apply the rules or the laws that the legislature, passes. Then secondly, counsel for the petitioner argued that the court committed another fundamental error of law when it stated in its ruling of 16th February that Section 26 of the Evidence Act is inapplicable. It wouldn't apply Section 26 because of Order 38, Rule 3E5. And just to break this down so that those watching can understand, counsel for the petitioner has argued, and we have explained or elaborated that point here on several occasions, that for us, Section 26 establishes the principle of estoppel. And that section basically says that if through your acts, statements, or omissions, you intentionally and deliberately makes another person to believe a thing to be true, then the truthfulness of that thing must be conclusively presumed against you, that person having relied on that representation from you. Which basically means that if per your actions you make me believe that you will do something, and I rely on that, the court should not allow you to resile from that position. And we have explained that. We are saying that Jean Mensah, through her depositions in at least 2 affidavits before the court, made it clear that she will be available for cross-examination to answer certain questions. And so she's bound by Section 26 under the rule of estoppel to change her position. And in that ruling, the court said, because of Order 38, Rule 3E5, we will not apply this. And we, today, counsel for the petitioner respectfully submitted that that was a fundamental error of law. Because number one, Order 38, Rule 3E5 has got nothing to do with the principle of estoppel and a witness or a person being, being held by the court as bound by a previous representation. That order has to do with a party having the rights not to call a witness who has already put in a witness statement. The purpose for us relying on Section 26 had nothing to do with the party. It had to do with Jean Mensah as a person. And so for us, that was completely irrelevant. And counsel for the petitioner further argued that even if there was any relationship between Order 38, Rule 3E5 and Section 26, Order 38, Rule 3E5 could not be interpreted or construed as having precedence over Section 26, because in the hierarchy of laws, a constitutional instrument is subservient to an act of parliament, and Section 26 is provided for in the Evidence Act, which is an act of parliament and which is superior to Order 38, Rule 3E5, which is a subsidiary provision made by the Rules of Court Committee. Again, counsel argued that the court did not take cognizance, or the court did not apply Order 38, Rule 10 of CI 47, which counsel indicated to the court that he was going to apply should leave be granted for the petitioner to reopen his case. He said, I will follow this rule, Order 38, Rule 10, which is basically the rule or the process for the issuance of a writ of subpoena. And that the court's decision did not make any reference, not only to Section 72 of the Evidence Act, but did not also make any reference to Order 38, Rule 10, which we had indicated that we were going to rely on to subpoena Mrs. Jean Mensah. Then he spoke about Article 19.3 and Article 296 of the 1992 Constitution, and Article 19.13, has to do with an adjudicating body acting independently, impartially, and ensuring that a case brought before that body, is conducted in line, fairly, in line with a fair hearing. And in our opinion, counsel for the petitioner submitted that if you look at the way the court has failed or refused to apply certain statutes, and the court appears to be shielding, in fact that is in his statement of case, shielding the EC chairperson from accountability or testifying, it is not fair, and it violates the petitioner's right to a fair hearing as stipulated under Article 19, Clause 13 of the 1992 Constitution and Article 296. And the question we always ask, which we would like to reiterate today, is that why must we go through all these tedious processes just to get a public officer who we pay as citizens of this country, a public officer who has discharged a certain constitutional duty by conducting elections and declaring the outcome of same? We are talking about Jean Mensah, the returning officer for the 2020 presidential election. Why must we go through all these hassles, all these troubles to get this woman to just give account of her stewardship, how she did her job, and how certain things happened, so that the courts can know the truth in these matters and do justice? If she has nothing to hide, if she has done nothing wrong, why must we go through all these tedious processes? Now, there were questions about, but you close your case voluntarily. Yes, we close our case based on the representations of the EC chairperson that she was going to be available for cross-examination. And at the time we were closing our case, we could not have subpoenaed her to testify because she had filed a witness statement and several affidavits which had made it clear that she was going to testify for the first respondent. And so the law and the rules of this court would not have allowed us to even subpoena her at the time. So this issue of, you close your case voluntarily, you cannot, no. The last time, the president of the bench stated clearly that it is a settled principle of law that a party can apply for leave to reopen his or her case after he has closed his case. And that is what we have done, and we believe that we have demonstrated that the circumstances or the conditions which are important for for leave to be granted in such circumstances have been demonstrated. The courts dismissed this application and said basically that we failed to show the reasons why we were seeking to subpoena Madam Jean Mensah. Now, because of time, I will not go through our statement of case and all that, but you can check paragraph 28 and paragraph 42, and you can see for yourself that counsel for the petitioner and the petitioner explained clearly why we need Jean Mensah to enter the box. We explained that she is the returning officer who made a declaration of 9th December. It is she who claims to have made errors. It is her outfit which purportedly sought to rectify that error through unlawful means. It is this same returning officer and her office who have sought to churn out conflicting and inconsistent figures. And that it was important, among other things I would say, it was important that she be made to enter the box, cross-examined, so that the truth in these claims could be unearthed for Ghanaians and the court to appreciate all these things. So we disagree with the court that we did not show why we are seeking to subpoena Jean Mensah and the usefulness of her testimony to the determination of the issues before the court. We believe that the evidence before the court shows that we did that. Again, the court, in interpreting Section 26, commenting on that, said that, there are certain conditions when it comes to promissory estoppel. Now, it's instructive to note that counsel for the second respondent, Lawyer Kutampa, had suggested that Jean Mensah didn't even make any representation to us that we could have relied on. And that what Jean Mensah did was basically to state the position of the law that she will be available for cross-examination. That was not a representation, was not an undertaking. Those were his words. Now, the court in this ruling says that it is a representation, but same cannot be said to be unambiguous. In other words, it is ambiguous. We have read those depositions over and over again. Those depositions are undertakings. Per Section 26, Jean Mensah is bound by same, And there is no ambiguity in those depositions. She says clearly that the petitioner will not suffer any prejudice or injury because the petitioner can solicit the answers he is seeking through interrogatories during cross-examination. And we believe she meant what she said. Before I conclude, again, the court spoke about Section 72 of the Evidence Act that counsel argued on in this case. And the court said that there is no inconsistency between the Black Law Dictionary decoded and Section 72. Yet the court still stands by its definition of who an adverse witness is, that a person must enter the witness box before he or she can be described as an adverse witness. Clearly, you can all download the Evidence Act 1975 and read Section 72 for yourself. It says that, among other things, a person whose relationship to a party makes his interest substantially the same as a party may be called. So you can be called to enter the box as an adverse witness. You need not be in the box before, on the basis of your adverse testimony, you are described as an adverse witness. And so there too we disagree with the court. But ladies and gentlemen, a lot happened today. We don't want to bore you with all the details. The bottom line is that the petitioner is worried that the courts, in deciding these applications, are not applying statutes that have been passed by our parliament, and statutes that the court has been applying in other cases. And we think that the petitioner is being denied a fair hearing, and it is important that these issues be pursued to their logical conclusion. Now, why are we doing all these things? We are doing these things because of the constitution that all of us as Ghanaians have agreed to be bound by. Article 63.3 of that constitution says that no person should be made a president until and unless he attains more than 50% of the total valid votes in any presidential election. And it is clear from Jim Mensah's own declarations and the figures contained therein that candidate Akufo-Addo did not get more than 50%. We've done the mathematics here over and over again, and you can do the mathematics yourself. He did not cross. And so the petitioner, John Dramani Mahama, His Excellency, is doing this for and on behalf of all of us, and is doing this in defense of the Constitution. And so we must all be interested in this case. Let me appreciate those who have been encouraging us and cheering us on. We really appreciate your encouragement. And we are assuring you that we are not giving up, we are not giving in. We are fighting this matter in the interest of justice and for God and country to its logical conclusion, so that tomorrow an EC chairperson or an EC will not arrogate to themselves the power to choose leaders who have not met the constitutional threshold that we have all agreed to work with. We don't want that bad precedent to be set. The will of the people must always hold sway over the will of a select few. And for those who are crestfallen, those who are discouraged, and sometimes call us worried, disturbed, why don't you withdraw this matter? Why you shouldn't even go to court? We want to tell them that we understand and appreciate your frustrations. We understand and appreciate that. And we are telling you, don't give up. We are not doing this for nothing. We know what we are doing. And we are doing this because of the love we have for Ghana, particularly that of the petitioner. And so let us all be patient with the legal team as we go through the process. We are not abusing the court processes like some are suggesting, and we have not defied the orders of the court. Everybody knows that any party dissatisfied with the decision of the court is entitled to a review. And so we are just using processes provided for under the laws of this country that we have all agreed to be bound by. And let me just say finally, like I said last week, that no matter how this case will go, no matter how the decision will go, because we are all discerning, because we all love the truth, because we are all following this case keenly, the truth will become clear to all of us and we will all see the truth. And don't always think that when people come to court and the applications are dismissed, it means they are wrong. No. What it means is that the court is right for the time being, and it is what the court has said that will prevail. Like now we disagree with the court, but whether we like it or not, what the court has said is the law, and that is what will prevail. But posterity will be the judge of us all. Just like it happened in the case of Ray Akutu, when the Supreme Court then unanimously dismissed the case brought before it by Joseph Dankwa, J.B. Dankwa, with regards to the unconstitutionality of the Preventive Detention Act. Today, even though the court held in that case unanimously that the presidential oath was akin to the coronation oath of the Queen of England and didn't constitute a Bill of Rights and all that, today, what is celebrated is not the court decision. In fact, that is the most unpopular decision in the history of this country, even though it was a unanimous decision. What is celebrated are the submissions of J.B. Dankwa. And we believe that posterity will judge us very well. Will judge us very well. Now, we are hoping, based on the indications that the court has given, that they may find it necessary for counsel to be given the opportunity to make some submissions, oral submissions, on the written submissions they have been asked so far. There's not been any clear indication to that effect that will be done, but the court says that if it finds it necessary, the court will do so. We think that looking at the considerable public interest in this matter, it will be important for that to be done. But if the court, in this wisdom, decides that they are not going to allow counsel to make any oral submissions, we will respect that, and we will be engaging you in the media, and we'll be sharing with you the content of counsel for the petitioner's written submissions. And so that's where we'll end it. If you have any questions, you can ask. Of course, in 2013 it was done. So we are hoping that that precedent, which is a very good precedent, will be repeated in this case.
Thank you. Two quick questions. The ordinary bench and the application to reopen, a 7-member panel, dismissed the application. We have an enhanced panel, 9-member panel, equally dismissed the application. Obviously, from what you have said, you are dissatisfied with the decision, but you have to file your address anyways, and you would have to do that, close the case, file your closing address without the benefit of the testimony and cross-examination of the EC chairperson. Question number one, are you disappointed? Question number two, is the NDC going to be seeking another opportunity to hold her accountable, as has been the talk all throughout?
Okay. So the first one, are we disappointed? Yes, we are disappointed. We are disappointed that, in our opinion, the petitioner is not being given a fair hearing. We are dissatisfied that, in our opinion, it appears that the EC chairperson is being shielded. We are dissatisfied that, in our opinion, and as articulated by counsel for the petitioner, known principles of law and statutes that our parliament has passed, that the court has previously applied, are not being applied to this case. So, in our opinion, we are not being treated fairly, and we are disappointed. But the decision of the court is what prevails. And to answer your second question, are we going to explore other opportunities or avenues to hold her accountable? Emphatically, yes. We will explore. We mean it when we say we will explore all options and fight this matter to its logical conclusion. Any other question? Okay. So, Baba will do this.
Yo, anyone, I say, ne court by no, in Sembe, you know, and a sea or court her. Yedi kan em say a system free twemu court si ginae bi ginae osi ni so on my ho kwan me mie yasem no mu sene ye be betimi afra ma meje mensa na waba abeka nanu mu nsa no wa kire ni esi wo abatro no enne ye samba say court nsan hwe ni ginae ne biom esan say yen adwemu de enim se ma meje mensa wa ma no kura wa asem ye hunu ono ana or declare election no or no ana o my figures different or no ana chirete na na Akufo-Addo wini a yen susie mu ne yankundabu mu no na Akufo-Addo wenya 50% plus one wenya enjiti e ba be kansem na so wono amma amaka bidia na chesa asem na kan no na enwie feyo ye kai enu mu nsem biara na nso court no ene ye anya adwen court no enyina ye ne se ono de ofose ma meji mensa ba enyeyi saa semi ene asem esi o court na yen ye gusu agina bebi agina se court na kasa de na ne court nso bɛka ɛna yɛ mmara bɛno nso nkyerɛ sɛ bɛsa wone court nya adwene a wontimi nka wasɛm ɛyɛ me nua kasa no ɔma decision bi a ɛmmerɛ bi court na si agyinaeɛ court nipa na wɔ hɔ nyinaa ka sɛ ne ɔma ka no na ɛnokorɛ na nsi ɛbɛ akyire no na asɛm no asesa enti yɛn yɛgyidie mu deɛ ɛnim sɛ asɛm no a yɛkɔ no neɛ court ka yei no waka deɛ na yɛn nso yɛ ne ɔmo nyɛ adwene yɛbɛsi yɛhyɛ Ghanafoɔ nyinaa bɔ sɛ neɛ yɛyɛ no ɛnyɛ sɛ yɛyɛ no kwaakwa yɛyɛ ne si anim neɛ yɛ John Dramani Mahama wɔto ne ho asi hɔ sɛ ɔbɛboa mu obiara court nsɛm a waka no obi ate aseɛ wetu no ho gyina hɔ sɛ nokora wɔ sa asɛm no mu ɛwɔ sɛ pie ɛnti sɛ obi gyina hɔ na ɔka sɛ bio adentina mo kɔ so yɛ adentina mo nya ne yɛpɛ sɛ obi ate aseɛ ne sɛ John Dramani Mahama ogusu gyina bebi ogyina ne yɛbɛyɛ biara kwan bi foforɔ bia wɔ hɔ na ɔsi yɛfa so ma maame no ɔbɛka n'anum nsɛm ma nokora no dɛ adi ma Ghanafoɔ tia inshallah yɛde wɔn bɛba salamu alaikum jamaa yau kuma mun zo court inda muka zo court abinda muka gani yau shine matan da ta saya aka yi wanga takara matan muna so ta zo ta shiga cikin takaran ta shiga cikin adaka ta yi magana mun yi court wai bai ra'ayi da mu ba amma abinda muke so jama'a su gane ba wai ka zo court na ka yadda maganan ka ya kare ba akwai hanyoyi da yawan da za mu bi ba kuma abin da za mu bari ba za mu ci gaba inda za mu bi matan ta shigo ta bari jama'a su gan gaskiya a me ya faru domin ita ta zo ta yi declaration nan ita ta sai aka yi takaran abin da aka yi duka ita ta yi to don me za zo a yi magana a ce babar ta shiga a daka don me za zo a kawo magana ta ce ba yadda yau mun zo kotu wai bai yadda da mu ba amma abin da muke so mu gane in kotu bai yadda da mu wannan bai gwada kama magana ta kare ba za mu ci gaba inda za mu bi magana ta kwanta matan ta zo ta faɗi gaskiya ko yau ne ko gobe ne ko zuwa gaba ne za mu bi mu bar ta zo ta yi gaskiya. Assalamu alaikum.
Please, Dr. Ayine will address you briefly. So.
Madam, we'll stand by. Let's all stand by him.
He's coming.
That's okay, I'll stand beside him.
Yeah.
I'm with their party for Dominic, that's okay, I'll stand beside him.
Okay. Thank you.
I'll stand beside him. I'll stand beside him.
Okay, all right. Yeah.
Let's
Okay. All right. Good evening, ladies and gentlemen of the press. I am here this evening in respect of the remarks that are made to you on the 16th of February after court proceedings. Those remarks were widely publicized by the media, and both mainstream and social media carried them and they went viral. I have looked at what I said that day, and I have come to the conclusion that I went overboard, I crossed the line with respect to the remarks that are made in terms of attributing impropriety to the Supreme Court of the Republic of Ghana. And I just wanted to let you know that this morning I delivered a letter to His Lordship, the Chief Justice, offering an unqualified apology to the court. Now that letter has been filed and the Chief Justice of the Republic has referred to it, I want to take the opportunity to read the content of that letter to you, and thereafter I will apologize and retract my words. Now, the letter reads, My Lord Chief Justice, summons to show cause unqualified apology to the Supreme Court. On the 16th day of February 2021, I addressed a press call at the premises of the Supreme Court in respect of a ruling that the court had rendered on that day. I did so in my capacity as a member of the legal team of the petitioner, with instructions to brief the press on matters of concern to the petitioner after court proceedings. In carrying out my instructions on previous occasions, I had always made certain that I explained the day's proceedings to the understanding of the press corps and of fellow citizens with civility, and without seeking to attribute acts of impropriety to the Supreme Court or the respondents. On the said day, I thought I had maintained that approach to the press briefing, but on hindsight, I actually crossed the line in suggesting that the court had a predetermined agenda, among others, to rule against the petitioner. My attention was drawn to this fact immediately after the press briefing by Frank Davis, Esquire, to whom I am grateful. It was not my intention to scandalize the court or to bring it into disrepute. In the circumstances, I wish to apologize unreservedly to the court. Yours sincerely, Dr. Dominic Akuruting Ayine, signed. And for those of you, I'm sure Mr. Frank Davis is not a stranger to the press. He's standing here to my right. I remember on the 16th of February when I finished addressing the press, he walked up to me and reminded me that the phrase that I had used, that there was a predetermined agenda, had crossed the line. And that is when I started thinking about whether or not I had crossed the line. And I agree absolutely with Mr. Frank Davis and those of you who think that I crossed the line on that day. I wish to unreservedly apologize to the court, that is the Supreme Court of the Republic of Ghana, as well as the justices in particular who sat on that day. There was no intention on my part to impugn their integrity. I was just expressing a sentiment with respect to the ruling of that day. And I want to render an unqualified apology and to retract the words that I used on that day in their entirety.
Unreservedly.
Unreservedly, I will not in any way want to disparage the Supreme Court of the Republic of Ghana. You can see I'm lost for words because I don't want to be, when you want to take a pegative, I was told that I should peg myself of the contempt. So you take the pegative so that you don't complicate the constipation. So I'm being very careful that the pegative I'm taking this afternoon will not complicate the constipation. And so I wish to thank the press for the opportunity to address you, because His Lordship the Chief Justice, in making the order, said I should use the same medium that I used in conveying the words that are the subject matter of the contempt proceedings. And so thank you very much, ladies and gentlemen of the press. I am hoping that my apology and retraction will be accepted by their lordships, and the matter will come to an end. Now, in respect of this matter, I plead with the press that I won't take any questions and provide any explanations. God bless you and God bless our homeland, Ghana. Thank you very much. Thank you.